Good afternoon, everybody. Thank you for joining me this afternoon for the Virtual Compliance and Croissant session on consent. My name's Jeanette Scott. I'm the Director of Legal and Regulatory Affairs from ADMA. We'll be spending about an hour together this afternoon just having discussion about the various elements of consent. For those of you who are live on the webinar, if you're having trouble hearing, please dial 1-800-896-323, then enter 811-76879. Just to take you through what we'll be covering today, there's a fair bit that we're going to look at in the area of consent. First of all, we'll have a look at the relevant legislation. We'll have a look at the types of consent, the elements of consent, what to do with abandoned shopping carts, business cards, personal contact information on websites, Tickboxes, sample consent notices, collection notices versus privacy policy, then withdrawal of consent or unsubscribe as we normally refer to it, the time that you have to action unsubscribe requests, keeping records of consent, data acquisition, third-party collection and ticketing platforms. We'll have a quick exercise just to check and see what you've learnt today. Then we'll have our question time. You're free to put through questions as we chat today, but it would be easier if you wait until the end and we can address all those questions together for you. Type them through if you think of them, and we'll spend some time working through the questions at the end of the session. And then we'll close, and hopefully I will have addressed all of your questions by then. If for some reason I haven't, then I'm certainly going to be addressing them for you and putting something up on our website. We will be recording this webinar and making it available on the ADMA website. It will be available, this particular webinar, both to members and non-members, and we will publish the link in one of the upcoming regulatory newsletters. So, on we go. Just a little bit about me. As I mentioned, I'm ADMA's Director of Legal and Regulatory Affairs. My background originally is as a barrister, more recently as a solicitor, and I have extensive in-house experience working specifically with marketing and advertising teams. I'm also a certified compliance professional, and I've worked in the regulatory compliance environment for over 15 years. I have a strong background in training, and I pride myself in having a very commercial and pragmatic approach. So hopefully that will come through for you today. Bit of fine print. I wouldn't be a lawyer if I didn't add some fine print. Just to note that today's webinar addresses consent in the context of the collection and use of personal information. Now, the information that we're discussing here is broad. It's not a complete overview of all relevant issues, and so it shouldn't be considered as exhaustive. Also, please bear in mind that this is general information only. It's not legal advice, and you should obtain legal or other professional advice before acting or relying on this information, as it may need to be tailored to your own specific circumstances. I always address what a session is about, and people usually always think it's about breaking the law, and it's true, it is about that. It's about how to avoid costly fines, but more than anything, I think compliance is about how to preserve your organisation's reputation. And we always say, take the customer's view. The legal answer might be one thing, but if you can comply with the law but you are not meeting customer expectations, then you're causing yourself reputational damage. So always put the customer's perspective in mind and don't just think, what does the law allow me to do? Think, what are my customers or prospective customers expecting from me? So we're going to start with the legislation that covers consent and use of personal information. In the collection space, the Commonwealth Privacy Act, it's a 1988 Act. You're probably all aware that it was last updated in 2014 when we had some massive changes come through. It's the key act that covers data or personal information generally, things like transparency. It covers disclosure and use of personal information, though not all uses, and we'll have a look at that shortly. It covers integrity and security of personal information and the access and correction of personal information. The Privacy Act is often referred to as an opt-out regime. So within its provisions, there are circumstances where you can collect personal information, use personal information, where people are given the option to opt out once you have collected that information. Now that's quite different to the regimes that apply for the next two pieces of legislation that we are going to be looking at, and that's the Spam Act and the Do Not Call Register Act. So those two pieces of legislation are channel specific. They relate to the use of data for commercial and electronic messages in the case of the Spam Act. So there we're talking about emails, SMS and MMS, and telemarketing calls in the case of the Do Not Call Register Act, which governs who can be called. So essentially, unless you're an exempt organisation or you have consent, then you can't call anybody who is on the Do Not Call register. And the sorts of organisations that do have an exemption from that are charities, political parties, educational institutions and the like, provided they are calling about things that relate to their own purposes. So, for example, a company couldn't ask a charity to make telemarketing calls on their behalf and plug their wares to get around the Do Not Call Register Act provisions. There are similar exemptions as well with respect to the Spam Act, in that charities, political bodies, religious institutions, educational institutions all have a partial exemption from Spam Act provisions, and they actually don't need to comply with the consent requirements or with the unsubscribe requirements of the Act. There's also a partial exemption that relates to factual messages. Be very careful when you're considering what is a factual message, though, because the regulators take a very narrow view of what is factual. So, for example, if you're sending out a new privacy policy, that might be factual, but if you let people know that you have a new premises, a regulator would probably see that as being a commercial communication. That's a little bit beyond the bounds of today's webinar, but just be very conscious of the difference between a factual email or electronic message and a commercial electronic message. Also in this space, when it comes to use for telemarketing and research calls, we've got the telemarketing and research calls industry standard. So that's not around consent, but it does set rules about when and how telemarketers can contact people and what sort of information needs to be provided in those calls or upon request. So just be conscious of the provisions of that standard as well. Now we move on to the types of consent. So in the broad sense, we have inferred consent and we also have express consent. So inferred consent is consent that could be assumed or inferred, not surprisingly, from the relationship with or the conduct of an individual. Now a lot of people believe that if somebody is your customer, that you can infer consent. That can often be the case, but you have to look and consider what the actual expectations of your customer are. If it's a one-off purchase, then that might affect whether or not they're expecting to hear from you again versus somebody who's purchasing from you regularly. You need to look at it in context and see what the expectations of that individual is. So always best to try and get express consent. That can be oral, or it can be in writing. If it's oral, it's a great idea for you to have a recording of it or to acknowledge it, for example, in a database to indicate that oral consent has been given. So where you have express consent, that's where somebody has actively agreed to you collecting and using their personal information. Just be aware that when it comes to sensitive information as defined in the Privacy Act, then you do need express consent. And by sensitive information, we mean the things defined in the Act, such as religious beliefs, sexual preferences, criminal history, those sorts of things that people would normally expect to be sensitive, and it would include health information. We move on to the elements of consent. There are 4 key elements to consent. Consent must be informed, it must be given voluntarily, it must be current and specific, and it must be given by an individual with the capacity to understand and to communicate their consent. So if we look at each of those elements in turn, first of all, informed. If a consumer gives consent by performing a certain act, for example registration, is there clear notice to the consumer? So let's imagine you have a form online and you say in that form, just prior to the submit button, by registering for this event, you give XYZ company consent to contact you about their various activities and so on and so on. Now, you can incorporate a consent statement into your wording, and you can cover off on the collection notice requirements as well, which we'll talk about shortly. If that is clearly brought to the reader's attention, then they're informed, they have notice of it. But if you had put wording to that effect, let's say right down at the bottom of the page, and they didn't even have to scroll that far before they hit submit, then chances are they never would have seen it. They haven't really made an informed decision to give you their consent because you haven't given them effective notice. So do make sure that you are very transparent in your dealings with consumers and that you make sure that the consent that they give you is informed. Move on to the next element. Consent must be voluntary. So has the individual been given a genuine opportunity to give or withhold consent? So it's similar to the informed element. Have you been very upfront and clear to them about what you're doing and why you're doing it? Have you given them a chance to say yes or no? Now, the way that we garner information these days for things like events and newsletter subscriptions, we usually include consent as part of the registration process. So if somebody doesn't want to part with their personal information, their choices either then are not to register for the event or to register and then unsubscribe once they receive their first communication. But it really depends on the type of data collection that you're doing. What are you collecting? What are you collecting it for? And is it possible for you to give people alternative choices? What are the implications if they don't consent? So, for example, if somebody was signing up for electricity, if there's a denial of service, this might perhaps be seen as duress or coercion. Originally, the regulators took quite a strict view on the notion of a forced consent, but when the changes to the Privacy Act came through, they didn't introduce a separate principle around consent and address the issue specifically. So it's up to us as good corporate citizens to make sure that we do what we can to not pressure people unnecessarily into giving us consent. When it comes to the direct marketing space, so I think it's fairly well accepted that we're going to be direct marketing to people, and that's the value proposition that we give them when they sign up. We say, by registering for this, you consent to us marketing to you, and here's a copy of our collection notice that tells you the things that you need to know. Okay, so avoid bundle consents where possible too. That's where you're saying by registering for this or by purchasing this, you consent to A, B, C, D, and E. The more that you bundle into a consent, the more it is the case that the regulators will take a view that you're forcing the consumer's hand, that they're not really being given a choice, and so consent really isn't voluntary. When it comes to marketing of goods and services, I generally look to try and separate out providing consent to for contact by partners and sponsors. So I'll quite often suggest that an organisation say, by registering for this event, you consent to XYZ company marketing to you, but then have a separate consent element for sponsors and partners to be able to contact people as well. It really depends on what sort of tolerance you think your audience might have and how you word the consent notice and the collection statement, and how well you bring that to the attention of the reader. Moving on to the next element, which is that consent be current and that it be specific. Here, we're just making sure that we seek individuals' consent at the time that we collect the data. So generally speaking, you should be collecting consent every time you collect personal information from somebody. If that's not feasible, and the onus is on you to show that it's not feasible, and the example that the Office of the Australian Information Commissioner gives in their guidance is a third-party data list. If it's not possible for you to get consent directly, then make sure that you do provide a collection notice to them at the first opportunity, one that complies with the provisions of APP5, and we'll talk about that later in today's webinar. And make sure that you don't contact them unless you have consent to do so, particularly when you're coming into the Spam Act and the Do Not Call Register Act worlds where you need consent up front. People often say, can I just email somebody to ask if they would like to be added to our marketing list? And the answer is no. In the Spam Act and Do Not Call Register Act world, you need consent up front, so you can't even send one email through to ask for that consent. You would have to make sure that you garner it through other ways, either face-to-face or by direct mail, or have something on your website and hope that they're going to give you consent through those means. Capacity. You've got to ask yourself, is the individual capable of understanding the consent decision and the implications of withholding consent? Now, there is a presumption that somebody has capacity unless you have reason to believe otherwise. So, for example, if you're speaking to somebody on the phone and you begin to suspect that they don't have the capacity to give you informed consent, then you shouldn't rely on that consent. If in doubt, don't rely. Look for other avenues. So, for example, if it's a young person, their parent or guardian, if it's somebody who has a physical or mental disability, then does somebody have power of attorney for them if that's relevant? The sorts of considerations that are often at play here do usually relate to things like age, incapacity and language. That is where people have English as a second language and may not understand the import of what you're saying or what they're doing. A quick note about a couple of specific issues. One of them is abandoned shopping carts. Just remember that if you're going to collect personal information from an abandoned cart, you need to have consent from the consumer in order to collect and use that information. Now, quite often, because we don't put consent provisions and collection notices in place until the last minute in checkout, it can mean that if somebody abandons their cart earlier, you don't actually have inferred or expressed consent. So look at the dynamics of the way that you're dealing with your shopping experience so that you can try and build in either inferred consent or express consent into the process. So, for example, you might have right up front at the start of the process a note saying that, should you not proceed with your purchase today, we'd love to keep you informed about future offers. Please tick here if you don't wish us to do so. So that might be an example of a way that you might address that issue. Next one is business cards. I'm often asked by people whether or not they can market to somebody who hands them a business card, or whether they can market to somebody who pops a business card in a bowl in a competition, say at an event. If it's in the context of a competition, they've popped it in a bowl, you should be addressing it in your competition terms and conditions, and there should be a collection notice that's available at your booth that people can look at to meet requirements. You'd also need to make sure that you comply with any competition requirements. And if you're not sure about competitions, we did run a webinar on competitions late last year. So there's a recording on the ADMA website, a webinar recording on competitions that will tell you all about trade promotion lotteries. So let's just go back to somebody who hands over their business card. Can you market to them? Really, what's their expectation? Did they ask to be added to your mailing list? Or did you tell them that you would add them to your list when they handed you the card? It's really about managing that expectation or seeing whether or not you can infer consent from what was said or whether you have expressed consent. So, for example, if somebody hands me their card and says, "Great presentation today, here's my card, can you add me to your mailing list?" Quite clearly, you've got express consent to do that. Remember that if you are collecting personal information, you should be providing a collection notice under APP 5. So if you can't do it on the spot, and that would be a situation where you wouldn't be able to, unless you happen to carry a copy of your collection notice in your pocket, and I can tell you now that even I don't do that, then what you should do is provide them with a copy of that collection notice at the first practical opportunity, and also include with that communication and all communications to them a prominent and simple unsubscribe notice. Okay, we move on then to websites. Another one that I'm asked about regularly, and that is, can we collect people's information off websites and market to them? This is known generally as the conspicuous publication rule. So essentially, if somebody puts their contact details on a website, their email address, you can infer that they've given you consent to contact them, provided, and we move on to the next slide that has the provided bits on it, that there's no adjacent statement saying that the information is not to be used for marketing purposes, that you only contact them about work-related purposes. So, for example, if it was somebody who was a doctor, you could contact them about attending an upcoming medico-legal seminar, but you couldn't contact them about joining the local golf club. And the third proviso is that you don't use automated address harvesting software. Okay, don't forget though that if you do use collection in that way, that again, people won't know that you have been collecting their personal information, so you should provide a collection notice that complies with APP 5 on first contact, and then a prominent and simple unsubscribe in every communication thereafter. Now we move on to tick boxes. Tick boxes are sometimes the bane of my existence. People often say to me, "Do I need a tick box?" Or they say, "But this doesn't have a tick box." There is no law that I'm aware of in Australia that relates to privacy that says you need a tick box, nor is there any law that I'm aware of that says it's illegal to pre-tick a box. What you must focus on is consent. Do you have consent or not whether or not somebody has ticked a box. Regulators often frown on pre-ticking boxes. They can be used with care, but I generally suggest seeking guidance if you want to use a pre-tick box. And the reason for that is this. A regulator sees the act of putting a tick in a box as an act of giving consent. So they say if the box is already pre-ticked, then there is no act of giving consent. That's the regulator's view or interpretation of the legislation. Our position is that that isn't actually what's said in the legislation. What you do need is consent. So there can be other things that do constitute the giving of consent or an act of giving consent. So, for example, if you have on a registration form wording that says, by registering for this event, you give us consent to XYZ, and that is provided clearly so that it's brought to the reader's attention and somebody then submits their information and registers. It's the act of registering or pressing submit that would then constitute the consent. So focus on whether or not you've got consent and look at the words that you've used and whether or not they have been brought to the attention of the reader. We'll have a look at a couple of examples here. There's two different examples of consent and collection notice statements. The first one, note that the box isn't pre-ticked. So you could say, please tick this box if you agree to receiving marketing communications from XYZ company in the future and if you have read and agree to our collection notice. We'll have a word about collection notices very shortly, but that's a short form way of A, getting consent, and B, providing the collection notice to people, which is something you should provide whenever personal information is collected. So that's one way of doing it. But what if somebody doesn't tick the box? Then you wouldn't have consent. Sample 2 says that the act of, in this case, providing an email address, or it could be registering for an event or purchasing a product. In this case, by providing your email address, you are consenting to receiving marketing communications from XYZ company in the future on the understanding that you've read and agree to our collection notice. So that's a way where the act of providing the email address or registering or purchasing is the act that constitutes the giving of consent. And that's the type of collection notice that I generally use, one that has consent and collection incorporated into it, and it gives you that way consent in every instance. If you think that people are going to be put off by that, you could go a little further and explain to them that they will be given an opportunity to opt out at every communication. So, for example, you could end it with your privacy is important to us, and by registering, you will be given an opportunity to opt out in every communication that we send to you. So it's really up to you to manage how you think your customers will respond to the collection of personal information and to put in wording that will address any particular concerns that they might have. Now to collection notice versus privacy policy. The Privacy Act actually has two specific APPs that relate to what you should tell people about collection, use, and storage of their personal information. So the one that we are most familiar with is a privacy policy. That is under APP 1, and it lists the really broad things that people should know about privacy in your organisation, like what security do you have in place, how do people make a complaint or find out more. This is usually the document that sits in the footer of the company's website. It says privacy policy. It's normally several pages long. It contains a whole heap of information. But there is also under APP 5 of the Privacy Act a requirement that you tell an individual at the point where personal information is collected specific things that are listed in APP 5. So I've written an article about this which is on the ADMA website. If you look in our regulatory e-news, there's an article on the difference between collection notices and privacy policies in APP 1 and APP 5, and that also lists the requirements that you have there for each of those two APPs and what should go into them. So keep an eye on the ADMA website if you want more information about collection notices versus privacy policy. But generally speaking, that collection notice for APP 5, some people call it a privacy statement. The Act unfortunately doesn't give it a name, so people call it whatever they're minded to call it. So you'll see different people call it different things. but it also usually contains in it a link to the broader privacy policy where people can find out more. So that's what I've been referring to when I've been talking about collection notices. Okay, now we move on to withdrawal of consent. I just wanted to raise a quick note here about the wording of unsubscribed statements. So be careful about the wording, that you use wording that does actually manage the expectations of people when it comes to what they're unsubscribing from. So for example, if you have an organisation that has 6 separate newsletters and somebody receives a particular newsletter from you, if they press unsubscribe, but that's only going to unsubscribe them from that newsletter, then ask yourself, what would be their expectation based on the unsubscribe wording that you have used? So would they realise that they're only going to unsubscribe from that one newsletter? Or would they be thinking that they would be receiving no further communications from you via email or possibly via any channel? Make sure that your wording is clear. And having said that, also make sure that you don't shoot yourselves in the foot by using wording that is so broad that you are taking people off or unsubscribing them from everything when that perhaps was not their intention. So what I normally suggest is something along the lines of, to unsubscribe from this newsletter, click here. To manage your preferences generally, click here. Then take them into a preference centre where they can be very specific about what sort of communications they want to receive from you. And preference centres aren't easy to build, I appreciate that, but the more that you can offer in terms of preferencing, the better you are. So the sorts of things you can look at is, what content do people want to receive? What channels do they want to hear from you by? What sort of frequency would they be happy to hear from you? Is it weekly or is it monthly or quarterly? And if you're a charity, so for example, you might have, do you want a tax time appeal or a Christmas time appeal? Or both or neither? Also think about snoozing options. That's something that's gaining a little bit of momentum. So let's just say that somebody's going to go overseas for 3 months. They don't want their emails mounting up. Some preference centres allow you to go in and to snooze for a period of time, which means that you're not losing that consumer from your database. You're actually managing their expectations and their wishes, and if anything, you're going to be building brand loyalty by giving them those options and empowering them. Time for actioning unsubscribe requests. This is a little one to watch out for. Under the Spam Act, you have 5 business days from the time that somebody requests that they are unsubscribed until you action that request. So if you have an agent who's been sending out emails on your behalf, I often see agreements that say the agent will send through an unsubscribe list once a month. Well, that would not be compliant because you've actually got 5 days from when the agent receives the unsubscribe request for you to get it on your unsubscribe list. So be conscious of that. The provisions in the Privacy Act and the Do Not Call Register Act are more generous. They're really worded to be as soon as possible, and a rule of thumb there work around a 30-day rule so that you are still meeting consumer expectations that they're not going to be hearing from you anymore. Another issue to watch out for is keeping records of consent. Both a consumer and a regulator should be able to ask you for information about the consent that you have relating to a specific individual, and you should be able to produce it. Now, a lot of platforms don't manage consent recording very well, and some of them don't have any sort of audit history, so you only have the most recent interaction on file. But do the best that you can to record consent. You should be able to show whether the consent was express or implied, or how it was obtained, if possible what the wording was, certainly how you got it, the date that you got it, and a copy of the information that they consented to. The way that I normally manage what did they consent to is that if it's my own organisation's data collection, on my collection notice I would use a code, and so the data set for that code would be attributed to that individual. So let's just say I ran a collection point at the Royal Sydney Easter Show on the 15th of March 2016, and I had collection notice there with a code 16123. Then somebody who entered their information at the Easter Show on the 15th of March, I'd be able to see that we got the information from the Easter Show, that the date was the 15th of March, and the tracking code on the collection notice would take me back to the wording that they had consented to at that particular point in time. Moving on quickly to data acquisition, be very careful when you're acquiring data that you check for consent and that consent is appropriate for your use. Quite often when people are sharing data, so there are various data co-ops out there, or they're acquiring data, say from a data vendor, there is an assumption that the data is okay for them to use, or people rely on assurances by the other party that it's okay for them to use the data. You need to satisfy yourself that you are actually able to use that data. So was the consent given broad enough for that data or personal information to be passed on to you? And is it broad enough to cover the type of content that you want to address and the type of channels that you wish to use? So make sure you have some sort of due diligence process in place around data acquisition that allows you to address those points and be satisfied of them, because remember that the onus is on you. Now on to third-party data collection and ticketing platforms. I have a background in the charity space where we often use third-party platforms for collecting donations and also ticketing of events. And I'm very conscious of the fact that a lot of these platforms don't have provision for you to include your consent statement and your collection notice. So I usually got around that by putting those things onto the landing page. So let's say it was registration for a charity event, then you'd normally have access to a landing page that you were able to edit quite freely. I would always make sure there was something prominent on there about click here to register, and by registering, I would include the consent statement there and the reference to the collection notice and a link through to the collection notice, which might have sat on our company's website. That way you can make sure that you're covering off on both the collection notice and the consent, even though you're using a third-party platform. A little bit of an exercise here now. Hard to do on a webinar, but I'm going to ask you just to take a moment to have a look at this picture. Let's imagine that everything that's on that slide is part of a collection form that you are using. The wording's very similar to the two samples that I provided earlier, but in this case I've used consent wording and a collection notice. So by providing your email address, you're consenting to XYZ marketing to you, and you've read and agreed to the collection notice. Then I followed it on with a tick box. Now, I see this more often than I would like to, but what you've actually done there is you've put in a consent provision, my doing this, you consent to that, and then you've asked them if they agree. So what you've done is put yourself in a position where if they don't tick that box, you won't have consent. Whereas if you had left off that tick box and just relied on the first part, which was sample 2 in the earlier samples, you would have collected consent from people who were registering in that instance. So it's something to be conscious of, I suppose, is look through your form and ask yourself, what would an individual think if they had filled in this form? What would they be expecting? What would they think they have consented to? I often suggest that you get somebody in your organisation who just hasn't seen what you've been working on to do a cold read and tell you what they think they're registering for, what they think you're going to be doing with their personal information, because chances are they will represent the average person and they'll give you an indication of what it is that consumers are actually expecting. Always a good test. Okay, so right now we're going to be moving on to questions in a minute. Before we do, I have a quick little plug for you. It's April and the end of this financial year is coming quickly to an end. We have a privacy and marketing compliance class that's an in-class presentation, not an online one. We have Sydney happening in 2 days' time. That's this Thursday, the 7th of April. And apologies if you're listening on a recording because you will have missed this. And we also have Brisbane on Thursday, the 28th of April. I'm going to offer a discount code to anybody who wants to email me directly at comply, COMPLY, at ADMA, ADMA.com.au. If you're interested in doing the Privacy and Marketing Compliance course this month and you want to save yourself 20%, just pop me through an email and I'll give you a discount code so that you can register. There are still spots available for this Thursday, so if you've got a window of opportunity there, jump in and go for it. Also, just want to let you know that that course will probably by the end of April be available online. We think our online courses are fantastic, but I will say also that it's great to spend a day in class with me so that you can go through your own real-world scenarios as well. And we do a lot of thinking on our feet and looking at different scenarios, which is a great benefit of doing that face-to-face. So we'll be able to offer you either option. The second plug that I'm going to make is just for our general training courses. If you want to commit to training by the end of April, if you pre-commit for the sum of $3,000 or more by the end of April, then we'll provide you with one free online short course in addition. So that's around $600 worth of value for free. You'd have up to 31st of December to book those courses as well. So if you want to save some money, it gives you an opportunity to get in now and then be able to undertake the courses a little bit later in the year. Again, if you want information on how to do that and save yourself some money, just send me through an email to comply@adma.com.au. So I can see that we've got a few questions here now, and we're also going to have Redback launch their survey so that you can give me your responses about today's webinar before we conclude today. So I'm just going to start working through these questions. And thank you all for sending your questions in. It's always great to know that people are listening and have questions for me. I'm just moving on to the first question, which is from a member organisation. And they say, if one of our members opt out of their communications, do they still have the right to call them later on down the track to ask them if they'd like to resubscribe and or invite them to a special event? Generally speaking, if they've opted out from everything, you would not be able to contact them to make another offer to them. It really depends, though, on how broad your unsubscribe wording is. So happy to have a chat with you, member, about that. If you want to send me an email at comply@, and we could log in a regulatory guidance call for that. Just to let you know, if you're not an ADMA member, it is one of the benefits, that's being able to book a regulatory guidance call with me, where we might have a quick chat about specific issues and I can point you to various resources. Even members with big in-house legal and compliance teams find this a useful service. Quite often it's another opinion, another perspective, and we can certainly provide the regulator's point of view because we have a lot of interaction with the regulators themselves. So I hope that gives you some indication. The next question that we have is, if we're sending out a service email, so we'd also refer to that as a factual email, if we're sending out a service email to customers regarding their account, do you need to give them an unsubscribe option? If it is a factual email, or some call it a service email, then there's a partial exemption from the Spam Act and you wouldn't need to include an unsubscribe. However, the regulators take a very narrow view over what a service or factual email is. So even if, say, you're sending an invoice out or a receipt out, if you then put a special offer on it, they're going to see that as being a commercial element, and as soon as that is included, then they are going to say that that actually is a commercial communication, so you would need to include an unsubscribe. Generally speaking, the regulators will encourage you to not rely on any exemptions and to use consent and unsubscribe and identification in all communications with consumers. However, in the context of factual information, sometimes that can get a little bit confusing for people, depending on how their unsubscribe wording is written and incorporated. I'm going to be writing an article shortly about factual versus commercial communication, so keep an eye out on ADMA's regulatory newsletter for that, and hopefully that will give you some more information on that topic as well. Now, the next question that I have here is, if a customer opts out of marketing, then later makes a purchase, can we contact them after they've made the purchase as long as we don't sell them anything? Well, this is where I would actually look to incorporate a fresh consent statement into your product purchasing so that you give yourself an opportunity to get consent back again. If you haven't got consent back, if you haven't captured consent when they've made that later purchase, then the only way that you could contact them would be about something factual. So let's say they'd bought something and there was a product recall, they'd bought something but they'd made an inquiry as to the warranty and you were just responding to that. So hopefully that addresses that question for you. Once you've lost consent, you've got to be very careful about how you might try to get it back again. Next question is, with reference to using an agent, what did I mean by that? It's a really good question. I'm sorry if I wasn't clear. Sometimes organisations use another organisation to send out emails on their behalf. So if you have somebody sending out emails for you or conducting telemarketing calls for you, then they would be the ones quite possibly who receive the unsubscribe requests. So if you are using an agent to do work for you and they receive an unsubscribe request, then make sure they pass it on to you within 5 business days in the case of the Spam Act, and as soon as possible in case of the Privacy Act and the Do Not Call Register Act. Our next question, I think we're getting towards the end of the questions now. If a customer requests online that we contact them regarding one of our financial products and the nominated time is outside usual marketing time frames, can we discuss our other financial products as well? In the context of providing advice to them about what financial products might be suitable for their needs, I think there could well be an inference in that case that they are happy for you to speak to them about other products because they might have called you about product A. However, in speaking to them, you might actually find that product B might be more suitable. That's a difficult one to answer without understanding more about exactly what might be told to the customer up front. But generally, it's all in how you manage their expectations. So, for example, you could respond to them and say, yes, we'd be happy to call you at 8 o'clock on Thursday evening, and we can certainly address product X with you and let you know what other products we have available that might be of interest to you. Please let us know if that time is suitable and if you're happy with that. So it's about building expectations and looking at whether or not you can infer consent from the communication that you've had. Now, just looking at, I think, no, we've got several more questions. Question about shopping carts. Reminder emails are becoming common. Is it okay to base on implied consent? If yes, do you need an unsubscribe facility? And is there an implied limit on how many reminder emails you could send? I don't think that you can just infer from abandoning a shopping cart that somebody has given you consent to contact them. That's why I said before that if you do have online shopping, you need to build an expectation or get express consent early in your shopping process by saying, if you don't proceed with your purchase today, we would love to contact you with additional offers. If you don't want that to happen, please click here. If you haven't done something like that to either get express consent or inferred consent, then you'd need to ask yourself, on what basis do you think you've got consent to contact somebody at all? If you think it might have been a technical error, if you have reason to believe that, you might perhaps be able to contact them with respect to that particular transaction and say, you abandoned your transaction, we believe there might have been a technical error. If you'd like to proceed, please let us know. But really, you'd want to have something to hang your hat on so that you could assert that it was a factual communication and not a commercial one. And I'd certainly be concerned about sending more than one email if you didn't get a response to the first one. Okay. Just going down to the next question. If there was only an opt-out box and the box was not ticked, then am I right in saying that the customer has not given consent to receive an email, call, or SMS? Actually, if it was an opt-out box and it wasn't ticked, then you could infer that somebody has given their consent ordinarily. But again, you want to make sure that the wording is very clear and that it's been brought to the attention of the consumer. So you might have, by registering for this event, you agree to XYZ company marketing to you about future events and offers, and that you confirm that you agree to the collection notice. If you do not wish us to contact you, then please tick the box below. So something like that. If it's clear, then if they don't tick it, then generally I would think that you could rely on that as being express consent. Next question, how do you generally manage consent when using a marketing automation system in which it collects unidentified behaviour data until the point where they complete a form in which they consent, and those unidentified data are added to their personal data? Okay, so when we're collecting information these days, the definition of personal information became broader under the new Privacy Act provisions. So personal information is information which identifies or could identify somebody. So we have to be careful about collecting information which in context, when merged with other information, can become personally identifiable. Generally we do this by putting things like cookie notices that come up when you go to a website that's saying, our website collects cookies, click here to find out more or to turn it off. And you'd also include that sort of behaviour in your privacy policy as well. You'd make reference to the fact that you collect information in that way and that you may incorporate it with other personally identifiable information to create a profile on somebody. So usually people are actually collecting consent, and you see that more and more these days with cookie notices and so on. Okay, I think we've addressed that one. We've got a question now about running competitions. Is it okay to include the substance of your collection notice and consent to marketing as a clause rather than a separate notice and or tick box? I generally say no. If you think about embedding it in your competition terms and conditions, you should say to yourself, will somebody have read this? Will it have been brought to their attention before the personal information is collected? And I think you're on fairly shaky grounds. You could put wording there that addresses it by saying, by entering this competition, you agree to competition terms and conditions, which includes our collection notice, and you consent to us marketing to you in the future. So you could do a broad statement like that that takes them to more detail that sits in the competition terms and conditions. But I'd be very, very careful about how you worded that and make sure that it's clear to people that information will be collected, they will be marketed to, that the collection notice is in your terms and conditions, and that those terms and conditions are available there for them to read. Next one is with respect to calls. If inferred consent is given, does this mean the data does not need to be washed against the Do Not Call register? Absolutely. If you have consent, that consent can be express or inferred. It's just always preferable to get express consent, because that way, if you're challenged, you can show somebody that you have expressed consent, either the regulator or the consumer concerned. If it's inferred consent, you'd want to be really sure that you have a reasonable basis upon which to infer that somebody has given consent, and that's probably beyond the realms of what we can address for you today. But be satisfied that you have got consent, and if you have, then you wouldn't need to wash against the Do Not Call register. So I think that's it for questions, and thank you for all those wonderful questions. We'll just cover off on a couple of quick housekeeping issues. The first of which is the Privacy and Marketing Compliance course. I've given you the plug for that already, but if you want to find out more, you can go to ADMA's website into Learn, or straight to the IQ website for ADMA, give you information on both that course and all of ADMA's other learning courses as well, and we have a whole suite of courses available to you. Stay tuned in our regulatory news for our next virtual compliance and croissants session. It'll be in approximately 3 months' time, and we'll let you know exactly when that's going to be and what the topic is. If you have any topics that you'd like us to cover, please shoot me through an email at comply@adma.com.au. And finally, for those of you who are members, a quick note on making the most of your ADMA membership. Make sure that you've subscribed to our emails, because they include a regulatory news. Make sure you've got a login for our Compliance Hub, where there are all sorts of compliance resources available as part of ADMA's Knowledge Lab. And also, as a member, don't forget that you can book a regulatory guidance call with me if you need a hand. Have a look in the Compliance Hub. If you can't find the answer, pop an email through to comply@adma.com.au with a brief outline of your questions, and we'll set up a time to chat. So, that's it for today, everybody. Thank you so much for staying with me and addressing the issue of consent. I hope you've had a great afternoon. Take care and goodbye.